Good afternoon. I'm Brian Patterson, and this is ENS. This afternoon, we welcome 7 panelists from 7 jurisdictions across the African continent. They are employment law experts joining us to discuss whistleblowing frameworks and practice. We will use South Africa as our benchmark and compare the other 6 jurisdictions to it. I'm hoping to cover 4 key questions in an hour. Each jurisdiction will have roughly 5 to 6 minutes in a Q&A format, and we propose to focus on high-level similarities and differences, not exhaustive detail. Perhaps, as lawyers do, may I introduce a caveat? The advice given is not exhaustive, it's illustrative, and no reliance should be placed on it in the absence of taking legal advice. Looking to South Africa, South Africa's regime is a very useful benchmark. Most of our panelists' jurisdictions protect good faith disclosures across public and private sectors with anti-retaliation remedies and recognize internal and regulator channels. The standouts in this regard are Namibia, where the flagship statute, I think still awaits full implementation. Charles Visser will assist us further with that. Kenya, which has just modernized its framework, and Faith Chabet will assist us there. And Ghana, which has a unique situation which pairs protection with potential rewards. So the 4 questions that we will raise are as follows. Question number 1, the legal framework and scope. Here we want to look at what's covered and what counts as a protected disclosure. Question 2, what are the protection and remedies? Here we are looking at anti-retaliation standards and what redress is available if harmed. Then question 3, reporting channels and confidentiality. What are the internal reporting channels in the country and in the employer's workplace? Does the regulator intervene? What public channels are there? How does one secure confidentiality and anonymity? And then finally, and perhaps the most important, what's the position in the jurisdiction on enforcement and trends? What does the law provide? But more importantly, what's the practical situation? Is there practical traction? Can one enforce these rights? And then finally, in some of these jurisdictions, there is some reform direction taking place. So I'd like to look at that. So it's a broad scope, not too much time. So we're going to start this afternoon with Jackie Driver. Jackie is a very experienced senior associate in our Johannesburg Employment Department. Hi, Jackie. How are you this afternoon?
Hi, Brian. Well, how are you?
Yeah, we're all good and looking forward to hearing you on the Protected Disclosure Act. Just tell us briefly in South Africa, what's the legal common law and statutory framework on whistleblowing?
So as you mentioned, there's the Protected Disclosure Act, which is the primary piece of legislation that governs whistleblowing in the workplace. Then there is also the Labour Relations Act, which refers to protected disclosures in the context of both an unfair labour practice as well as an unfair dismissal. The Act covers quite a wide range of individuals. While there is no legal definition of whistleblower in the Protected Disclosures Act, there are 2 definitions which are relevant, the employee definition and the worker definition. And essentially what these definitions do is they cover current and former employees, they cover independent contractors, consultants, agents, and temporary employment services.
So it seems to me, Jackie, it's pretty wide, and we're just looking at employment. It covers virtually everyone except what an independent contractor.
Yes, that's correct, Brian. It in fact also covers independent contractors in the definition of worker. So almost everyone is included vis-a-vis an employer.
Right. So let's say there is a protected disclosure. What are So what? What's the consequence of that to the employer and the whistleblower? What are the protections and what remedies arise from that?
So the Act provides that an employee cannot suffer an occupational detriment as a result of making a protected disclosure. It's quite important that the employee or other person make a disclosure, which is something relating to possibly a criminal offense having been committed, where someone fails to comply with a legal obligation, where the health and safety of someone is endangered, where there's unfair discrimination, where there's a miscarriage of justice. There are a variety of different forms of disclosure. Then it also has to be protected. It has to be made to an employer, a legal advisor, or certain prescribed bodies as defined in the Act. Also, they have to be made in good faith. The person disclosing the information needs to have a reasonable belief that it's true, and it needs to be made to the appropriate body, and it should comply with the employer's internal procedures in that regard.
What happens, Jackie, if it's not in good faith? We all know, particularly in South Africa, that often a whistleblowing report is made as a precursor to disciplinary action or action result of poor performance. And it's not always made in good faith. Is there any consequences associated with that?
Yes, the Act provides that in circumstances where someone makes a disclosure that is not in good faith, there are certain penalties that will apply in those circumstances.
Do you, as an employment lawyer, can you conceive of a scenario where something is manifestly not in good faith, that the employee might be able to discipline and dismiss that employee for under the misconduct provisions?
Indeed, indeed. So in terms of their disciplinary code and procedure, they would be entitled in those circumstances to take disciplinary action.
But presumably would tread warily in case it's misconceived rather than malafide or in bad faith.
Indeed. Indeed, it would depend on the facts.
Okay, so we've got a feel. Thanks very much for that. We now have a whistleblower who's reported has made use of the internal channels. Are there wide internal channels in South Africa? Are there whistleblowing lines? How does that ensure anonymity, confidentiality? What are the rules regarding internal as opposed to external reporting?
So whilst there aren't any specific rules in the Protected Disclosures Act relating to whether or not an employer must implement its own whistleblowing line, or that can be dealt with by a third party, or it can be done by a third party that is not in the country in which the organization operates, there certainly is an obligation on an employer to authorize appropriate internal procedures for receiving and dealing with and taking steps in relation to protected disclosures. And there's also an obligation to tell employees what those procedures are and what is required.
Is it normal to have whistleblowing hotlines through accountants, auditors, and law firms conducting certain circumstances? Whistleblowing.
That is certainly an option for employers. There's no specific provisions in the Protected Disclosures Act that deal with that, but there is just a general obligation on employers to have whistleblowing facilities.
Is there a timeline in which an employer has to acknowledge a whistleblowing report?
Yes, 21 days.
And what must how must the employer respond?
The employer must indicate whether or not they must make a decision within 21 days as to whether or not they're going to conduct an investigation or not, or whether or not they're going to refer the investigation to an external third party. And they're required to inform the person who makes the protected disclosure, assuming it's not anonymous, or advise employees generally that an investigation will take place or an investigation won't take place.
When, in your experience, is an employee, an anonymous whistleblowing report, employee entitled to bypass the internal processes and procedures, if at all?
The difficulty that presents itself with anonymous whistleblowers is even though the evidence might be sufficient for the purposes of conducting an investigation, in circumstances where there may be action may need to be taken, it may be difficult for an employer to produce sufficient evidence for the purposes of, for example, securing the dismissal of a fellow employee who's apparently committed the impropriety in circumstances where they're not facing their accuser and there isn't an opportunity to cross-examine that individual. So there is a limitation on that, but certainly employers can use other means necessary to try and ensure that they have sufficient evidence in order to secure a dismissal in this example.
No, Jackie, if an employer reacts adversely to a whistleblower and discriminates against the whistleblower, what remedies are available legally and in employment law in this regard?
So there may be disciplinary action that may be taken. There may be a suspension, a lack of promotion, a demotion. Those would all fall under an unfair labor practice. And where there is a dismissal and the employee has made a protective disclosure, there may be a claim for an automatically unfair dismissal, which obviously, as you know, Brian, carries a 24-month penalty as opposed to a 12-month penalty. The employer's obligation is to protect employees against suffering occupational detriment. So in the event that there's any harassment, any bullying, any retaliation, the employer can take steps against those who bully, harass, or intimidate, and can certainly dismiss them.
Equally so, it seems to me this is the sort of area that courts may well intervene if there is retaliation in the midst of the matter, which they're not normally keen to. Have you had some experience in that regard in South African law?
Indeed, Brian. There are circumstances under which our courts will make determinations in that regard. So an employee could approach the Labour Court for relief in those circumstances.
And the South African legislation, just to end off, Jackie, is there any reform changes likely to take place? Do you know if anything is mooted in the near future?
Yes, so we were all very excited on the 29th of June 2023 when a discussion document was proposed in order to, which proposed reforms to the current whistleblowing legislation. During his State of the Nation address, President Cyril Ramaphosa said in February of this year that discussion document would be taken further and that further the whistleblowing protections bill would be introduced. There are a number of changes because, as you know, Brian, we've had some significant difficulties with whistleblowers, particularly in the public space, making certain allegations and then suffering in some circumstances quite dire consequences as a result. So there's definitely a need for more protection of whistleblowers. And there are a variety of different amendments to the current Protected Disclosures Act that create, for example, a fund to assist whistleblowers. They provide legal assistance. They permit anonymous oral or written disclosures. So it effectively widens the scope of the current Protected Disclosures Act and takes into account the realities of making protected disclosures in the workplace, particularly in the public sector.
Okay, well, Jackie, I think that gives us a great overview of where we are in South Africa at present. Thank you very much. We may come back to you. If there's any questions on what Jackie has said, please post them. I don't see any questions yet. And maybe over now to beautiful Namibia, where we have Charles Visser. Charles, how are you today?
Well, Brian, how are you?
I'm good, thanks. If I recall correctly, you've got the Whistleblowing Protection Act of 2017, and I'm not sure it's enacted. Is it in force? How does Namibia deal with whistleblowing? Is it a piecemeal approach? Do you think it's going to come into effect someday, sometime? Please give us an overview of what the position is in respect of your current legal framework and scope.
Thank you, Brian. Yes, correct. We have a wonderful piece of legislation called the Whistleblower Protection Act, Act 10 of 2017. It was passed by Parliament, but has not yet brought into operation. And it's a bit of a pity because you've probably picked up references in the media to the infamous fish rot matter, fraud scandal, and that case is basically the evidence in that case of at least a criminal prosecution is heavily based on whistleblowing and whistleblowers and information obtained from that process. Unfortunately, we then sort of operating within a grey piecemeal area, and there's various pieces of legislation which may have bearing or may not have bearing. There's also an act called the Witness Protection Act, Act 11 of 2017. Unfortunately, that act was also has not fully been brought into operation. The Anti-Corruption Act gives protection to basically all persons, including employees. So there's certain limited jurisdictional basis on which employees can approach the Anti-Corruption Act. There's the Protection of Information Act. And then there's generally internal policies and procedures that are put in place by generally the bigger corporate entities, corporate employers who have their own internal policies and procedures, much following the process that is in place in South Africa. And generally, these are South African companies.
You've got your common law as well, which obviously is rich and
correct,
but not the easiest to enforce in this area.
Correct. So we find ourselves sort of a bit in limbo. It is. I don't think whistleblower protection has received the necessary prominence that it has listening to Jackie. That it's received in South Africa. It is obviously something that is well considered and valued by the legislature, and they've created a wonderful piece of legislation. But for some of the reason, this thing is not being put in operation. It's unfortunate. But looking at the Act and hoping for the Act to be implemented in due course, it follows much the same ethos and underlining basis that Jackie described. It is a comprehensive piece of legislation. It effectively covers a wide span of coverage that is protected. Any person effectively can raise a dispute and a concern. Likewise, as in South Africa, it must be in good faith, based on reasonable belief that the information that is presented is substantially true. It effectively deals with anti-retaliation provisions, quite heavy fines and imprisonment or imprisonment 75,000 Namibian dollars or 15 years imprisonment for any in this instance employer who may be tempted to get involved in anti-retaliation, or for that matter. But likewise also imposes quite severe penalties for a person, a whistleblower who makes intentionally false reports, 100,000 or 20 years imprisonment. So I'm gathering that would be a guide that you would follow. It's not legislation, but just so that our viewers, if they were looking at Namibia, let's say you acting for a corporate and there's an anonymous whistleblowing report, what would you be saying to Namibian management about the process and the risk of not approaching it correctly, retaliation, and the process that they should follow in respect of whistleblowing? What's the practical advice to corporate Namibia companies in respect of whistleblowing? Well, I think what is important is that at the current moment, and listen, this can change in any moment. The minister may give notice in the Government Gazette, and this act may come into operation as early as tomorrow or shortly thereafter. So we are a bit in limbo. But I think it's very important that corporate entities, clients appreciate that currently, as we speak, whistleblowing and the enforcement of whistleblowing is effectively internal company governed process. And it's critical to have the necessary, or to consider implementing the necessary policies and procedures to to deal with those scenarios and incidents. So effectively, the employer has carte blanche. He can set the policy and the procedure to be followed and deal with internal whistleblowing rather than try and avoid it. So,
but if you're sorry, because I want to understand this myself, if you're dealing with an international company, say out of Delaware, and has an operation in Namibia, and it has a very well-developed whistleblowing policy, and that isn't followed by local management, and it's applicable, what would be the recourse of the employee? Presumably they could rely upon that to some extent. It might have consequences in the Namibian labor courts if they were dismissed. I mean, is that really where one finds the teeth of whistleblowing?
Yes. Correct. Because at currently, as we speak, the employer has the prerogative to establish these policies and to enforce them, enforce them, and that goes with confidentiality and the nature of the disclosure, etc. So we find ourselves outside a statutory regime or regulation, but rather within the realms of our common law, the principles of fair disclosure, and internal company policy and procedure. And it may very well be that policy and procedure may very well emanate from Delaware in the United States.
And presumably a failure to comply with these policies may cause reputational damage, which sometimes of more concern to employers than a mere legal compliance with local legislation and law. So Correct. It's not of no consequence. That's what I'm saying.
Correct, because ultimately the employer is entitled to set the standards, and non-compliance with whatever standard, being a whistleblowing standard or not, may ultimately be visited with consequences. But the point that I want to make, Brian, is that it's still within the hands of the employer to regulate that process. Unlike in South Africa, where it's obviously a very highly regulated concept, and where Namibia is about to move into once this act has been brought into operation.
So I know in that cupboard behind you, you have a crystal ball. Do you have any idea when the legislation is like? Is there any talk of it, or is it very much on the back burner at the moment?
Very much on the back burner, and it's a bit of a concern, to be quite honest. You know, it is a 2017 act, and you would have expected that by now the minister would have brought it into operation. As I said, fish rot is a very contentious matter, and it assumes a lot of prominence within our courts and the work. So. It would have been of huge assistance, I think, if this act was in operation and at least to protect the evidence, the information, the report, etc. Currently, there is none. As I said, there's also this Witness Protection Act, which plays a lesser part in our discussion this afternoon, but also that piece of legislation has been brought into operation on a piecemeal basis. So we are actually in a grey sort of unregulated area currently.
Charles, thank you. That's a very clear exposition. Let's now move to my colleague in Kenya, Faith Shabet. Good afternoon, Faith.
Good afternoon, Brian. How are you?
I'm always well. It's always a pleasure to speak to Nairobi. And you've heard Jackie Driver on South Africa and Charles Visser on Namibia, and there's significant links in employment law with Kenya and South Africa. Do you want to just tell us what is the regulatory system in Kenya in respect of whistleblowing?
Definitely. Thank you, Brian. I think the first thing I'd like to say is it sounds very interesting hearing about Namibia and South Africa, because what I'm just getting is that the substance of the legal framework is very much similar in terms of what the requirements are, what the standards are. So Kenya derives the regulatory framework for this across different statutes. We do have, similar to Namibia, a bill that's not really been passed yet into law around whistleblower protection, but the substance of this is covered across different related statutes like the Employment Act, a variety of anti-corruption legislation for both public and private sector. We do have what we call the Access to Information Act, and that establishes an independent office called the Office of the Ombudsman, who is also sort of entitled to receive complaints around, whistleblowing and related, both from mostly from the public sector, but including also private sector where there might be an overlap. There are regulators as well for employers who are operating in regulatory spaces like banks, insurers, telcos. Then the regulators also have sort of a hand around whistleblower protection and the requirements around that. So whilst we're still also waiting for the proposed Whistleblower Protection Act to sort of formally come into force, in the meantime, we are deriving this regulation from the various statutes that I've mentioned. But the important thing, I think, is to just take away that the substantive requirements are very, very much the same. Yeah.
So you don't know when this Protection Act is likely to be enacted. It's like Namibia, you're waiting at this point. But presumably also like Namibia, Faith, particularly with the multinationals, and there are many in Kenya, they all have very much generic whistleblowing policies similar to the we've been discussing, and compliance with that would be required, and there would be consequences if there wasn't compliance, I assume.
No, definitely. All the multinationals will have very detailed policies, global standards around this, whistleblowing policies, independent portals for reporting, procedures for how this kicks in once a report comes in. So definitely that framework is there. And compliance is really enforced in the sense of not just the legal consequences or repercussions, but even just the reputational consequences. These are the kind of things that tend to be picked up in the media quite quickly. And I mean, no employer wants to be pegged on a headline around an issue like this, whether it's merited or not. It just sort of very untidy. Yeah.
It's reputation, but I know from my limited dealings with Kenya, retaliation is an important aspect of your law. I presume retaliation for whistleblowing finds consequences in your employment law and dismissals and the like. Could you just give the viewers an indication of what the consequences may or may not be if one retaliates, or there is in South African parlance an occupational detriment as a consequence of someone's bona fide whistleblowing act?
Oh, it's dire. I would say it's dire. Kenyan courts, that's the kind of issue they take very seriously. If an employee sort of suffers any type of retaliation because of whistleblowing, and that matter winds up to court, the damages, can be quite significant. It becomes, whether there's been termination of employment or not, any type of even just internal retaliation, whether it's subjecting them to discrimination, segregation, failure of promotion, and things like that, even just before you go into disciplinary or termination. All of that is sort of substance that can go to court, and if it lands in court and it's been a bona fide whistleblowing complaint that's been raised and the employee has been retaliated against, then it's something that the courts take very seriously. But in addition to that, it can also have criminal consequences for the employer in the event that the whistleblowing incident sort of relates to something that has a nexus with the criminal law, whether it's anti-bribery and corruption or anything else. Then it can be seen as something that's sort of like interfering with access to justice and the judicial system in that sense as well.
My understanding that interim injunctive relief is possible, compensation, severe compensation by way of damages, and potentially reinstatement of the employee in appropriate circumstances. Are those all possible remedies in Kenyan law? Yes,
they're all possible in Kenyan law. The damages there can be, if it's like a case of termination of employment, it can be capped at, say, 12 months worth of the employee's salary. But the interesting trend that we're seeing is that where the case has constitutional ramifications, then courts have lifted that cap, and there's no either time limitation or financial limitation as to what the amount of damages can be. For remedies such as restitution or reinstatement to employment, it's there in the law. It's not very commonly enforced, but we've started to see this as a trend that courts, especially in the public sector, will order reinstatement. In the private sector, maybe not so much, but we've seen 1 or 2 cases recently where reinstatement has actually been ordered by court. Yes.
So it seems to me, for a jurisdiction that has a Whistleblowing Protection Act that isn't in force, there is an ethos, a culture, and a willingness by the Kenyan courts to take this incredibly seriously, both from an employment law and constitutional perspective, and exact significant redress if you are in breach of fair whistleblowing practices. I mean, is that a fair summary?
Absolutely, Brian, absolutely. And I should add also that, so the employment court is very, will always try to enforce the rights of the employee that's in force. And then I mentioned earlier about the constitutional angle of this. Then there's a specialized constitutional court that sort of has the locus to take on any aspect of this that touches on the breach of constitutional rights of the employee in question. And then we also have an ethics and anti-corruption court that's a specialized court, so that where these issues have to do with any type of bribery, anti-bribery, corruption, AML, and all of that, then there's a specialized court for that as well. So there's been this attempt sort of from different angles to try and tackle this issue, because it's an issue that has, historically been quite a big issue in this country.
And if you were to take your crystal ball out of that drawer of yours, Faith, and prophesize when this legislation might come in, any idea, or is it just in the air? What's delaying it?
I don't think that there's a lot of appetite for it currently. There was a lot of talk about it last year, in 2023 towards last year, but now, I mean, there seems to be this feeling that it's been deprioritized, just like Namibia, I must say, and that's quite disappointing. So I wouldn't be expecting it, at least not within the next 1 year horizon scan. Yeah.
Well, thank you very much. That's very comprehensive, and I'm sure it gives the viewers a very good indication of the dangers of loose whistleblowing policies in Kenya. And we're going to move across the Indian Ocean to the beautiful island of Mauritius. And my colleague, Emmanuel Sauzier. Are you there, Emmanuel?
I'm here. Hi, Brian.
Bonjour, ça va?
Ça va et vous?
That's as far as my French extends. Will be happy that I'm not going to continue. Emmanuel, you've heard Jackie Driver on South Africa and Charles Visser in Namibia, and also Faith on Kenya. And I'm aware, Mauritius has the Protected Disclosures Act, I think, of 2016. Just, is that in force? Do we have a piece of legislation that's in force? And can you just compare to South Africa where we are in whistleblowing protection in Namibia?
Well, thanks, Brian.
Not in Mauritius, I'm obviously in Mauritius.
Being restricted to employment law purely, we do not have yet any piece of legislation which is on or relevant to whistleblowing in Mauritius. I've heard Charles on Namibia, and similarly we have the Financial Crime Commission Act, which replaced our former Prevention of Corruption Act from 2002, which protects and gives protection to people reporting financial crimes in Mauritius, both in terms of anonymity and in terms of protection from retaliation. As far as employment law, pure employment law is concerned, we are yet to receive legislation in Mauritius, and we don't have anything yet in the pipeline. But it does not mean that employees reporting potential wrongdoings would not be protected under our current employment law. And from hearing other colleagues, I would say the salient test would be the same. One would have to look at whether any reporting by an employee is a reporting made in good faith.
Yes.
But on the other side, the limits would be that the protection would be restricted to employment law and employees only, so that the likes of suppliers, contractors, and former employees as well may not be protected.
So it's not as wide, Emmanuel, as in South Africa, but what I'm interested in is, to the extent there is a bona fide report from a whistleblower and a company, maybe an international company with internationally accepted whistleblowing policies, just doesn't comply, retaliates, victimizes that employee, and maybe dismisses them. What are the potential remedies in employment law in its widest available to such an employee?
There would be various remedies available to an employee. And I think we'd have to differentiate between two maybe broader categories of retaliation. If coming from the employer, and as you said, ending up in a termination of employment, the employee may choose to apply for reinstatement in their position. They may also claim severance allowance, which can be quite high in Mauritius. For an order of idea, we're talking about 3 months remuneration per year of service. They could, if victimized and made subject to harassment, they could choose to claim a broader breach of contract and claim damages, contractual damages, from the employer. So the range of remedies is quite wide.
Do you think is there any opportunity to obtain injunctive relief to stop it taking place, or protection before the damages fully manifest themselves?
It could be possible, but I would have doubts as to the effectivity and the willingness of our courts to grant injunctive reliefs for such issues. They might say you do have remedies, but they are before the industrial court or the employment relations tribunal, not with the judge in chambers, we call here, for who has the jurisdiction for injunctions. So I think a judge in chambers might not see any urgency. So they may say you have remedies, but elsewhere. But then I mentioned to you earlier two broad categories, and I think the second one would be retaliation and harassment from other employees in a company. And it is important to know that employers can see their criminal liability engaged here. They can be vicariously liable for the acts of harassment of employees towards colleagues. So that would be something to bear in mind as well.
Right. And using your crystal ball, Emmanuel, do you see any sign of legislation being introduced in the near future, or is it just is there any appetite? Is it an unknown at this stage?
I think there are pretty decent chances that we will see a specific piece of legislation in the years coming. We've seen that in practice, similarly to Namibia, most of the larger clients and the larger corporate conglomerates are already equipped with internal whistleblowing policies. So the practice is here, and as we often see, the practice is often in advance compared to the willingness of the legislator to move. So I think whistleblowing is akin to other employment subjects such as data protection, where the rules are quite similar across the jurisdiction, and there is a willingness to familiarize and adhere to what is being implemented elsewhere. So I think in the coming years we will see a specific piece of legislation. Yes.
You have a very large grouping of French and European and African investment into Mauritius. So most of those international corporates, as you say, have significant advanced policies and keeping the best practices in the world. And if they breach them, then presumably you can enforce them in terms of Mauritian law. They provide you a basis for relief. Is that correct?
Well, enforcement, I'm not sure, but it's definitely something that a court or a tribunal would take into account in terms of good faith from the employer. As so far as the policy remains internal, it might be hard for one to enforce it. But if an employer is not willing to act accordingly to its own internal procedure, this is definitely something a court will take into account when assessing good faith.
Emmanuel Sozia, thank you very much. That gives us a great feel for the position in Mauritius. And
thank you, Brian.
I'm going to now go to Patricia in Ghana. Patricia, are you there?
Hi, Brian. It's Marianne.
Oh, is it Marianne? Sorry, I thought it was Patricia coming on. Hi, Marianne. You've heard what's been said by the other panelists. Give us an idea in Ghana what the situation is from a regulatory perspective. What legislation and regulations are in place to protect whistleblowers in the employment context?
Okay, so in Ghana, we have a Whistleblowers Act whose provisions are very closely aligned to the case in South Africa. The Act makes reference to employees and to just generally members of the public. So both employees and members of the public can make disclosures under the Act. The definition for employees does not include independent contractors. So independent contractors, suppliers, former employees would fall under the category of other members of the public when making disclosures. In order for disclosures to qualify under the Act, there are 3 conditions that must be met, as Jackie mentioned. The disclosure must be made in good faith, the information must be believed to be substantially true, and the disclosure must be made to the appropriate bodies. There's an entire list of about almost 20 entities that disclosures can be made to, ranging from formal institutions like the police, the Attorney General, Auditor General, and also to more traditional bodies like family heads, religious institutions, chiefs. Depending on where you find yourself, you make the disclosure to the appropriate body. And once the disclosure is made, the body has 7 working days to refer the matter to the Attorney General, who will take it up and refer it onwards to any other institution it believes is capable to undertake the necessary investigations.
Okay. You've got an old legislation, your whistleblowing legislation, I think goes back to 2006, if I recall.
2006, yes.
So it's well established. There's also, I read somewhere, please correct me if I'm wrong, a unique aspect to Ghanaian law that there's sort of there's a carrot and a stick. You know, there's carrots or benefits to complying and reporting. Can you tell us a little bit about that?
Yes, so the Act establishes what is called a whistleblower reward fund. And what it says is that any proceeds that are obtained as a result of a disclosure, 20% of that has to go into this reward fund, and 10% of whatever is obtained is required to be paid to the whistleblower as a reward, and must be paid within 14 days of the proceeds being obtained by the government. Yeah.
Now, how has that worked out? Because the obvious cynicism is that it encourages false whistleblowing, potentially, as much as it might encourage people to justifiably whistleblow. I mean, how has it worked for Ghana? Because I'm not aware of any other jurisdiction that has that. So it's an interesting concept.
Yeah, the thing is, Brian, that the fund really is not operational. This is really just something that is in the law. There's no record of any accounts being set up So it's really just something that's in the law that's yet to actually be implemented. Yeah.
So this is a fair warning to our viewers. In many jurisdictions, the legislation is one thing, the practice is another. So you need to talk to people like Marian and these other panelists to know exactly how things are done. So let's understand, a client comes to you, in corporate Ghanaian client, and says, look, we have a whistleblower. We've acted badly. We've breached our policies. We're an international client. We're worried about our reputation. The whistleblower has been victimized. The whistleblower was dismissed, and they're taking us to court. What can we do to, other than settle? What can we do? And what sort of redress can that whistleblower get? What's the risk to the company?
So what the Act says is that the whistleblower is required to, as in the first instance, to make a complaint to a commission called the Commission for Human Rights and Administrative Justice. So that commission has the right to order reinstatement if the employee has been terminated, if the employee has been transferred to another office or institution or affiliate company. The commission can order a reversal of the transfer, or if a transfer to the institution they were at before would be for some reason not feasible, order a transfer to a different establishment. That's the port of first call for a whistleblower who has been victimized by an employer. The commission's orders have the same effect as a high court judgment, so that's quite effective. The whistleblower can also, apart from going to this commission, make a case in the high court for damages to be compensated if they feel they need to. Specific to employees, if they were terminated, under the Labor Act, they can make a case for unfair termination, and compensation comes with that as well.
Is there enhanced compensation similar to South Africa, where terminating a whistleblower unfairly would be an automatically unfair dismissal and result in up to 24 months compensation? Is there something similar?
No, we haven't seen as high as 24. It usually starts from about 3 months salary. That's the average that we tend to see. Going up to 24 months it seems a bit extreme.
And is it normal for Ghanaian corporates to have fairly well-developed whistleblowing policies and hotlines and the like? Is that part of business?
Yes, so the Act does not make having a whistleblower policy or hotline a requirement, but what we see from our clients, the more well-established international companies, the Ghanaian subsidiaries would usually just work off what is being used at the group level. So that's what we tend to see. There's no express requirement to have one.
And just finally, Marian, is there any developments on the horizon? Is there anything changes coming, or is that current legal or legislation on whistleblowing established, and there's no likely developments in the near future?
In terms of whistleblowing itself, no, we don't see anything on the horizon coming up. What we do see is there's a bill that is yet to be presented to Parliament that has been drafted by the Ministry of Communication that has to do with transfer of certain kinds of data among public institutions, or between public institutions and private institutions and public institutions. And that covers what is called public interest data, which we are looking at may seem to include disclosures that are made under the Whistleblowers Act. So the bill seems to just the vision is to create a more secure platform by which such information are distributed or shared amongst institutions, just for confidentiality and security purposes.
And do you get any injunctive relief, or is that unusual?
Very unusual, very unusual.
Well, Miriam, thank you for that very comprehensive exposition of Ghanaian law. I think that gives us a good feel for what's happening in Ghana. I'm grateful to you. I want to move now to Uganda and to my colleague Tracy, who is a senior associate in our Ugandan office. Tracy, good afternoon to you.
Good afternoon, Brian. Thank you.
How are you today?
I'm well.
We can't keep speaking to each other. We seem to be doing a lot of business together at the moment.
Yeah.
The Whistleblowing Protection Act of 2010, I think, in Uganda, and English common law, I'm assuming not too dissimilar to South Africa, but with its own differences. Do you want to just tell us what is the regulatory regime in Uganda?
Yes, that's correct. Our regulatory regime is quite similar to South Africa. We have a Whistleblowers Protection Act of 2010, which covers protected disclosures. Who can make these disclosures? Employees, both private and public. And the definition of employees is broad. It covers contractors. So it also applies to the general public as well. So basically, anybody can make a disclosure. Like South Africa, the disclosure must be made in good faith. The person must reasonably believe it to be true. It must be made to an authorized officer, and they must maintain the confidentiality of the information in order for the information to be protected. On what qualifies as a protected disclosure, this is limited to impropriety of a public interest nature. So criminal information, corruption, or any other unlawful act, failure to comply with a legal obligation, a miscarriage of justice, or a deliberate concealment of any of these criminal offenses. The disclosures for employment can be made internally. The Act is not very clear on regulating those internal disclosures, so we would then rely on internal policies of the company and the Employment Act. And then with respect to external disclosures, like Ghana, the Act lists a number of institutions that external disclosures can be made to. And interestingly, we also have a rewards system. If the disclosure leads to recovery of money, the individual is entitled to 5% of the proceeds.
Oh, so you're a little bit a similar provision, and has there been abuse of that, and does it happen?
We also haven't seen anyone recovering the 5% in Uganda as well. It's just something that's in the law for us, but we haven't seen it being implemented.
So I think our viewers would be interested if one were to look at a case where corporate Ugandan company, internationally based with a very sophisticated whistleblowing policy, doesn't follow it, retaliates, victimizes the employee leaves, maybe there's a constructive dismissal, but there is a claim. So let's look at that. Maybe first question on that, whilst it's occurring, is it possible that there could be injunctive relief, or is that most unlikely in Uganda?
It's unlikely. We haven't seen it, although that option would be available to apply for an injunctive relief.
So now the damage is done, the employee's left, you've got a constructive dismissal claim, and there's a clear victimization, retaliation in respect of a bona fide whistleblowing matter. What's the consequences to the company of that?
So the consequences are first that there are criminal penalties in the Whistleblowers Act. Not very heavy, about $670, but there's also an imprisonment element of up to 5 years. Then there are also the no more employment reliefs, which would be reinstatement. A labor officer could order reinstatement, compensation for unlawful termination. There'd also be general damages. Previously, our courts followed the common law position and maintained minimal damages in employment cases, which only related to the statutory benefits that the employee would be entitled to. But now they've expanded that, and judges are giving hefty general damages in employment matters, unlawful termination matters. The highest we've seen is about $300,000.
Right. And maybe just to end off, Tracy, any changes on the horizon? Anything? Any new legislation on whistleblowing? Any changes of approach, or is it very settled and in Uganda? And are there cases? I mean, this is something that is not just academic. It does occur in Uganda. Is that right?
Yes, it does occur, especially on the employment side. And the courts will clearly make the distinction between what is a protected disclosure and what's a normal employment grievance. So they'll only enforce the act in relation to protected disclosures. They'll also enforce procedural fairness issues. So if an employee is accused under the disclosures, under the whistleblower protection, they'll need to take them through a fair hearing and all of that. In terms of the law, we don't see anything on the horizon. The law is pretty settled on whistleblower protection. Yeah.
Well, again, a very clear, succinct exposition of Ugandan law on the subject. I thank you so much for your input. I'm sure the viewers understand much more their position in Rwanda today. Thank you. And I'm now going to move to Rwanda. Last but not least, where is Irv on on the call this afternoon? Is Rwanda here? Right. Good afternoon to you.
Good afternoon.
You've heard all the other panelists. If you could just give us an idea of what the legal framework and scope is in Rwanda.
Yeah, thank you, Brian. We're very similar to Uganda, I think. Our law is from 2017. Maybe the only difference will be it applies to also employees, but also former employees, as well as suppliers of any institution. And it covers any disclosure provided is related to an offense or any illegal act or behavior.
Right. And again, the question I put to others, let's say someone has been has made a bona fide whistleblowing report, international company in Rwanda. It has its sophisticated whistleblowing policies. They act in breach, and the employee is victimized, discriminated, and the subject of a constructive dismissal. Firstly, do you think injunctive relief is a possibility in Rwanda, or is that a non-starter?
Yeah, it's possible through what we call an urgent application. They can get that relief. But in general, they could get, up between 3 to 9 months of their salary if confirmed that it was constructive dismissal as a form of retaliation. There is the civil route, but they can also file a criminal complaint before the investigation bureau, considering that victimizing a whistleblower is a criminal offense. So they can go either way.
And how serious is that here from a criminal perspective?
Victimizing a whistleblower can be sanctioned by imprisonment of 3 to 5 years.
Okay. So it's not something that's taken lightly.
No, it's not, and practice dictates that it's taken seriously on all levels of government. Employers maybe not that much, but any information disclosed to the government authorities is taken seriously.
And if the individual is constructively dismissed, and it's not a normal constructive dismissal, it is one that arises out of whistleblowing, is there an enhanced compensation, or do the courts generally grant higher levels of damages for that sort of behavior?
No, because the Labor Act is clear on the damages following any form of dismissal. It doesn't make any exception to to whistleblowing retaliation.
So maybe for our viewers, what are those damages?
It's what I said. It's the 3 to 9 month
Yes.
salary, depending on the length of the employee, the length of the employment.
And what about re-employment or reinstatement?
That is unlikely because it's not provided by the law, and case laws have not entertained it so far.
Okay. And maybe just finally to wrap up, because time is short, is there any sign of any changes in legislation, any developments in this area, or is it very settled in Rwanda?
It's settled. The law has been in place for some time, and we don't see any change soon.
Well, thank you, Yves. That's a clear exposition. I'm not seeing any questions. It may well be my connection. I'm not entirely sure why that is. If anyone else is aware of any questions, let me know. Absent such questions, it just remains me to thank all the panelists for their participation today. I thought this was most valuable. I think that the similarities are greater than the differences. And although there are local differences in different jurisdictions, understandably, and the corporates that we act for must respect that and obtain local advice, they can be assured that following normal internationally accepted fair whistleblowing practices will carry them a long way to local compliance, and that there are significant dangers in these jurisdictions of not complying. So I think this is an area that we're expecting developments, particularly in Namibia and South Africa again, and we'll watch it carefully. It's been wonderful getting together with my colleagues and discussing this. We intend to do more of these African employment law webinars, hopefully one more before the end of the year. And I'm looking forward to our viewers joining us again at another time on another discussion and learning about African employment law. So thank you so much for joining us this afternoon. Thank you. Goodbye.